Climate law matters. The UK's net zero plans declared unlawful again. Hello, listener, and welcome back to our podcast, Climate Law Matters, in which we explore the legal developments across different sectors to address the key issue of climate change. I am Steph David, a barrister at 39 Essex Chambers, specialising in environmental and climate change cases. Today, I'm extremely lucky to be joined by Catherine Dobson, a leading junior barrister also at 39 Essex Chambers, specialising in public and environmental law, and instructed as counsel for Friends of the Earth in their recent successful challenge to the Carbon Budget Delivery Plan, in respect of which Mr. Justice Sheldon handed down judgment on Friday, the 3rd of May, 2024, and I'll refer to the case as the CBDP claim. She also acted on behalf of Friends of the Earth in the net zero case from July 2022, when Mr. Justice Holgate declared the net zero strategy unlawful. Catherine, thank you very much for joining me. To start, what is the Carbon Budget Delivery Plan?
Yes, good question. Under Section 14 of the Climate Change Act, the Secretary of State is obliged to lay before Parliament a report which sets out how she intends to meet the carbon budget set under that Act. And that includes her current proposals and policies for meeting the carbon budgets. Why does the Act contain this obligation? Well, the courts have now ruled on that, and they've held that a Section 14 report serves an important function in the overall statutory scheme set up by the Climate Change Act to ensure that the government achieves its net zero target. What the courts have said is that the reason that the Act requires the Secretary of State to lay a report before Parliament, rather than, for example, sending it to a regulatory body such as the Climate Change Committee, is to ensure that the government is transparent about how the targets are to be met and is able to be held accountable to both Parliament and the public.
Thank you, Catherine. So just to set then this particular claim in context, why did Mr. Justice Holgate declare the net zero strategy unlawful and directed that a further report should be published?
So the net zero strategy was the Secretary of State's first attempt to set out in a Section 14 report how she intended to achieve the sixth carbon budget. The Carbon Budget Delivery Plan was the Secretary of State's second attempt. The net zero strategy was successfully challenged in a judicial review. And in that case, Mr. Justice Holgate held that it was unlawful for a number of reasons. These included that the Secretary of State had not been given sufficient information about the quantitative contribution that individual proposals and policies were expected to make to the emissions reductions required to meet the carbon budget. So that was in relation to the underlying Section 13 exercise that the Secretary of State carries out in advance of publishing a report under Section 14. So the background to that finding was that material disclosed in that first set of proceedings showed that BEIS officials had advised the Secretary of State that only 95% of the emissions reductions required to meet the sixth carbon budget would be achieved by quantified policies and proposals. And Mr. Justice Holgate said that without information on the quantitative contributions that individual policies and proposals would make, the Secretary of State could not rationally decide for himself how much weight to give that assessment that 95% of emissions reductions required would be achieved. And what Mr. Justice Holgate said was that he needed the information to decide whether the strategy he was being advised to adopt was overly dependent on particular policies or whether the overall figure of 95% was too high. So that was the first key finding. The second reason that Mr. Justice Holgate found that the net zero strategy was unlawful was that he found that it had not included sufficient information to explain how the proposals and policies were intended to meet the carbon budget targets. He held that the Section 14 report had to include the quantitative analysis carried out by BEIS and also how it was judged that the 5% shortfall, that's the difference between the 95% of quantitative emissions that the policies and proposals were projected to produce, how that shortfall would be made up by unquantified proposals and policies.
So his findings in that case very much turned upon the statutory construction of Sections 13 and 14 of the Climate Change Act. What was his determination in respect of any obviously material consideration when discharging those statutory obligations?
In the part of his judgment considering the obligation under Section 13.1, Mr. Justice Holgate was focused on what information the Secretary of State had to have in order to reach a lawful decision under that provision that his proposals and policies will enable the carbon budget to be met. And what he held was that the quantified effect of individual policies was an obviously material consideration, because without that information, a Secretary of State could not rationally decide for himself how much weight to give the assessment that the quantified proposals and policies would achieve, in that case, 95% of the emissions reductions required.
So moving on to the Carbon Budget Delivery Plan challenge, and to set it in context for the listener, what process was followed in the lead up to the Secretary of State approving that report?
So yes, this is one interesting aspect of the judgment of Mr. Justice Sheldon. He sets out in the judgment the process which is followed by the Secretary of State to make decisions under Section 13(1) of the Climate Change Act, and then to produce reports for the purposes of Section 14. And what we learn from the judgment is that the starting point is officials in the Department for Energy Security and Net Zero work out the emissions savings that need to be achieved to meet each carbon budget. And that is done by comparing projections of what emissions will be across a particular period if nothing is done, to give a baseline, with the carbon budget for that period. So the difference between the baseline and the carbon budget is the emission savings that need to be made in order to meet the carbon budget. The next step is to collect details about proposals and policies for reducing carbon emissions from across government. And again, this is explained in the judgment. It explains that details of proposals and policies for carbon savings are collected through a mechanism known as a policy commission, which takes place quarterly. And essentially, each department is asked every 3 months to provide information about proposals and policies for decarbonising the sectors for which the department is responsible. In the lead up to the Carbon Budget Delivery Plan, departments were asked to provide returns in a template and to ascribe each individual policy and proposal a RAG rating, that's a red, amber or green rating, to reflect the degree of delivery risk. And we know from the information disclosed, and this is set out in the judgment, that green policies had a very high degree of confidence, amber policies a medium degree of confidence, this is confidence of delivery, and red a very low degree of confidence of delivery. So one of the issues that had been raised by Friends of the Earth in their challenge was that the Secretary of State had not been provided with these RAG ratings. Instead, departmental leads were asked to provide a narrative summary of delivery risk to replace the RAG ratings that had been provided in the returns from each department. So having collected information from individual government departments about their policies and proposals, the next step, and this isn't really addressed in any detail in the judgment, but it can be inferred, is that officials within the Department for Energy Security and Net Zero put together a package of proposals and policies, some of which are quantified and some of which are unquantified. And these are then put to the Secretary of State as the proposed package for delivering carbon budget targets and ultimately the net zero target.
It is interesting hearing about that commissions and returns process, because that was a factor in the global feedback case as well from a different angle. But then moving on with the Carbon Budget Delivery Plan claim, what was the headline issue in that case?
So the claim raised a number of issues. There were multiple grounds of challenge, but at its core, the claim was concerned with what information the Secretary of State needs to be given about the degree of delivery risk associated with individual policies and proposals in order to reach a lawful conclusion that she has a package of proposals and policies that will enable the carbon budgets to be met for the purposes of Section 13.
And just kind of building on that then, what were the grounds of challenge?
So yes, as I said, there are numerous grounds of challenge, but the judge grouped them into 3 issues, so I'll set them out in that way. The first set of grounds related to the Secretary of State's decision under Section 13(1) that the policies and proposals set out in the Carbon Budget Delivery Plan will enable the carbon budgets to be met. The first issue was whether the Secretary of State had, as a matter of fact, proceeded on the assumption that all the quantified proposals and policies would be delivered in full. And this turned on the meaning of the written advice provided to the Secretary of State by officials in advance of that Section 13 decision. The second issue was whether the Secretary of State had sufficient information about the delivery risks associated with individual policies and proposals in order to take a lawful decision under Section 13(1) that the package will enable the carbon budgets to be met. The third issue, and this is the second set of issues, related to the legal test to be applied under Section 13.3. And that is the provision under the Act which requires that proposals and policies taken as a whole must be such as to contribute to sustainable development. And the issue there was whether the statement in the Carbon Budget Delivery Plan that the overall contribution of policies and proposals to sustainable development is, quote, likely to be positive, satisfied the obligation under Section 13.3. And the third issue was about the obligation under Section 14 and the information which had to be included in the Carbon Budget Delivery Plan. And here, the issue revolved around the fact that the advice to the Secretary of State had included a table which set out in narrative form the delivery risks associated with each individual proposal and policy. By contrast, the Carbon Budget Delivery Plan included only sectoral summaries of delivery risks. It didn't include the information about the delivery risk associated with each individual proposal and policy that had been provided to the Secretary of State.
And so what did Mr. Justice Sheldon decide on that first issue, the Section 13.1 point?
So on the Section 13.1 point, Mr. Justice Sheldon's principal finding was that the Secretary of State was, as a matter of fact, advised by his officials that each of the individual proposals and policies would be delivered in full. And that conclusion was based on an analysis of the written advice and what he considered to be a reasonable interpretation of that advice. He concluded that if the Secretary of State did make his decision on the assumption that each of the proposals and policies would be delivered in full, then that was taken on the basis of a mistaken understanding of the true factual position. The Secretary of State had acknowledged in the case that not all of the policies and proposals would be delivered in full, so that finding followed from that concession. Mr. Justice Sheldon went on to consider whether the Secretary of State would have been highly likely to reach the same decision even if he had not made the assumption. And this is for the purposes of applying the test under Section 31(2)(a) of the Senior Courts Act. And he pointed out in his judgment that this required him to consider whether there was any basis on which the Secretary of State could have concluded that 97% of the emissions required to achieve the sixth carbon budget would be delivered even if not all of the individual policies and proposals were delivered in full. And he held that the Secretary of State did not have the information to carry out that evaluation. And that was because the narrative on delivery risk, which had been provided to the Secretary of State, did not enable him to work out which policies were likely to miss the target and by how much. And then finally on this point, on the Section 13.1 point, Mr. Justice Sheldon also considered what the position would be were he wrong about the assumption made by the Secretary of State. That is to say, he hadn't proceeded on the assumption that each of the proposals and policies would be delivered in full. And this is really the critical part of the judgment in terms of the broader implications. What the judge said was in that case, the decision under Section 13 would still have been flawed because the Secretary of State was not provided with sufficient information as to the obviously material consideration of risk to the individual proposals and policies. Mr. Justice Sheldon was clear that there was no obligation to provide the Secretary of State with the RAG ratings, that had been Friends of the Earth case, or to present the information on delivery risk in a particular format. But he was equally clear that the information which was provided was incomplete because the Secretary of State was not given information which enabled him to identify which individual proposals and policies were likely to miss their targets and by how much. And this was necessary in order to work out for himself the cumulative risk affecting the various policies and proposals in the package as a whole.
One other interesting point that was raised in this context is the point regarding information from the devolved administrations. Do you mind explaining that in a little bit more detail?
One of the arguments that had been advanced on behalf of Friends of the Earth was that the Secretary of State had insufficient information about the policies and proposals for which devolved administrations are responsible. Now, the Secretary of State's evidence on this point was that the devolved administrations hadn't provided much detail in their returns during the commission. There was, and this is key, there was no quantification of projected emissions savings attributable to the proposals and policies for which devolved administrations are responsible. The Secretary of State, nonetheless, decided to take into account those proposals and policies as quantified proposals and policies. And to do this, she scaled up the emissions savings that would be delivered in each area based on an assumption that the policies and proposals for which devolved administrations are responsible would have similar effects to those adopted by the UK government. And as I said, Friends of the Earth had argued that as a result of the lack of information provided by devolved administrations about delivery risk, there was simply no basis on which to assess the delivery risk of the policies and proposals for which devolved administrations are responsible. But the judge rejected this argument. He accepted that the information provided by the devolved administrations was limited, but went on to say that it was not obviously irrational for officials to proceed on the assumption that those policies and proposals would likely have similar effects to the ones adopted by the UK government.
Turning now to that second issue, which is the Section 13(3) issue in relation to whether or not the proposals and policies contribute to sustainable development. What exactly did he consider that provision meant?
So the judge found that the use of must in Section 13(3) connoted a high degree of certainty which was not satisfied by the assessment that the policies and proposals in the Carbon Budget Delivery Plan were likely to contribute to sustainable development. As you recall, that was the wording in the Carbon Budget Delivery Plan. And in support of this conclusion, he stated that the high degree of certainty required did not impose too onerous an obligation on the Secretary of State, given that the requirement is that proposals and policies will contribute to sustainable development, not that there will actually be sustainable development. So his reasoning was firmly based on the text of Section 13(3), but also considering whether the implications of that textual analysis would impose too high a burden on the Secretary of State.
And then that third issue then in respect of information in the Section 14 report, so the Carbon Budget Delivery Plan itself, as you say, that ground of challenge turned on essentially 2 points, whether it's sufficient simply to have a high-level summary of the delivery risk and the sectoral summaries rather than the risks to individual policies. And what did Mr. Justice Sheldon decide on that particular ground?
So Mr. Justice Sheldon dismissed the Section 14 challenge. Now, this part of the challenge was advanced by Friends of the Earth and the Good Law Project. Although there were some differences in the way that the case was put, the common thrust of the challenge was that a Section 14 report must include delivery risk associated with each individual policy and proposal. It was not sufficient to have a high-level summary of delivery risk or a summary of delivery risk on a sectoral basis. And the logic of this argument was that as delivery risk associated with individual proposals and policies is a mandatory consideration which the Secretary of State has to take into account when deciding whether policies and proposals will enable the carbon budgets to be met for the purposes of Section 13(1), it had to be included in the Section 14 report so that Parliament and the public understand the basis for the Secretary of State's conclusion. But Mr. Justice Sheldon said that this was wrong, this information was not necessary. He endorsed Mr. Justice Holgate's finding in the earlier net zero strategy challenge that a Section 14 report must set out how proposals and policies will enable carbon budgets to be met, and agreed with Mr. Justice Holgate that this requires a description of the proposal and policies and the contribution that each proposal and policy will make to achieving the object. But, he said, there is nothing in the statutory language of Section 14 which required delivery risk about individual proposals and policies to be included in a Section 14 report. And he actually went further and found that there was nothing to suggest that the inclusion of summaries of delivery risk for policies and proposals at the sectoral level needed to be included. The reason he gave for this conclusion is that risk factors and how they're expected to be overcome don't explain the policy or proposal, but they address operational means of delivering those policies or proposals, things like the funding that needs to be found or the legislation that might need to be enacted. And so it's an operational consideration, doesn't go to the how. And I think that reasoning, that element of Mr. Justice Sheldon's reasoning may prove to be key when it's linked back to his reasoning on the Section 13 challenge. So he'd found, if you recall, that the Section 13 exercise was flawed because the advice as to the overall emission reductions likely to be achieved by policies and proposals did not take into account the delivery risk associated with individual policies and proposals. He wasn't prescriptive as to how the Secretary of State would need to go about factoring in that delivery risk, but he did suggest that one possibility would be that the quantification of emissions reductions forecast for each policy and proposal could be adjusted to reflect the degree of delivery risk. Now, if the delivery risk associated with individual policies and proposals has to be factored into the emissions reductions that each individual policy and proposal is likely to achieve, then it seems to me that this information about delivery risk is part and parcel of the how proposals and policies will enable the carbon budgets to be met, and therefore information that needs to be included in the Section 14 report.
Thanks, Catherine. Could you provide a bit more detail on that?
Yes, because we know from Mr. Justice Holgate's decision, and this section was approved or endorsed rather by Mr. Justice Sheldon, a Section 14 report has to set out how policies and proposals will enable carbon budgets to be met. And that requires not only a description of the policy and proposal, but also the contribution that they will make, as in the emissions reductions. Now, if the consequence of Mr. Justice Sheldon's judgment on the Section 13 exercise is that quantification for each individual policy and proposal has to reflect somehow the delivery risk, the risk that that policy or proposal will not in fact be implemented in full or at all, then you actually build into the quantification of the policy and proposal the delivery risk. So you end up in the Section 14 report with that information, albeit it might not necessarily be set out in separate components.
I see. But then is not in any way kind of undermining the transparency point.
The problem, the difficulty is that unless it's made clear how that calibration exercise is carried out, if we're just given in the section, and by we, the public, Parliament, are just given the final figure of the emissions reduction that each individual policy and proposal has carried out, it's not possible to scrutinise without getting the underlying working out how that exercise was performed. And that was particularly important at this stage when we haven't yet seen that exercise carried out because the Secretary of State didn't think it was necessary to do that. And in fact, one of the submissions made on behalf of the Secretary of State was that exercise would be too complicated and too time-consuming. And Mr. Justice Sheldon said, whilst he didn't underestimate that it would involve some complexity, it could be dealt with. And as I say, he suggested one way of doing it would be some sort of calibration of the emissions reductions that each policy or proposal is predicted to produce, calibrated to reflect delivery risk. But we will want to understand how that exercise is carried out. And Mr. Justice Sheldon did address this at the very end of his judgment. And he said that this was in response to a submission made at the hearing, that the problem with his reading of Section 14 is that there's no right of the public to see information about delivery risk. And he said he wasn't invited or expected to consider the application of the Freedom of Information Act in this context, but he did raise that as a possibility. And then he also noted that Parliament may be able to call for this risk information, given that the Section 14 report is provided to Parliament. So it's really a watch this space, cross that bridge when it needs to be crossed approach.
Interesting. Certainly a lot of points to draw on from that. And I guess as well in terms of the question about how onerous the task would be, obviously, except when you have separate legal proceedings going on. But ultimately, the report only needs to be produced every 5 years. So that would certainly make it seem less onerous.
And in fact, the onerous part of this exercise is the working out that needs to be done as part of the Section 13.1 decision. And we know that's because the courts have said, including the Court of Appeal and the Global Feedback case, that the obligation under Section 13.1 is a continuing one. That exercise is ongoing. And it happens every 3 months that the Secretary of State is presented with a package of proposals and policies and invited to consider whether they will enable carbon budgets to be met. So that information should be, in order for that decision to be lawful, provided to the Secretary of State. So it's not a case of having to do more working out. It's a question of whether or not there's an obligation to include it in the Section 14 report. And you may ask, since that information is available, why not include it in the Section 14 report? And that was really the crux of the issue in this case.
So one of the points that I thought was quite interesting from the judgment is the point made by, I think, the Good Law Project, or on behalf of the Good Law Project, in relation to the duties to give reasons. And that was sort of a way in respect how much information is provided in the carbon budget delivery plan. he reached the conclusion that it's inappropriate to draw any analogy as between carbon budget delivery plan and decisions in the planning context or in other forms of litigation. Why did he reach that view?
Yes, the judge rejected that argument. He said the analogy with the common law obligation to give reasons in certain contexts was inapt, and essentially said that those cases involved disputes between parties on issues of fact or issues of law, and that in those cases, fairness requires that the losing party understand why he or she is lost, and that consideration doesn't apply here. But what he didn't address is that the common law has recognised other justifications for a duty to give reasons, which apply to decision-making by public bodies more generally. It's not confined to the context of litigation or a public law decision that only affects one individual. And one of the justifications that the requirement to give reasons enables interested parties to see whether the decision maker has erred in law or not. In other words, it improves transparency and enables decision makers to be held account. And those are both reasons which the court has said underpin the rationale for imposing an obligation on the Secretary of State to lay a report before Parliament under Section 14.
So what happens now? I mean, what's the remedy in this case?
So the court has ordered that the Secretary of State must lay before Parliament a new report which sets out the Secretary of State's proposals and policies under Section 13 of the Act, and which is compliant with Section 14 of the Act. And he has to do that by no later than the 2nd of May 2025. So it's the same remedy, in effect, that was ordered under the first challenge to the net zero strategy.
So watch this space. What, in your view, are the broad implications of this case?
I suppose the most immediate consequence of this case is that it's likely to have an impact on the way that the Department for Energy Security and Net Zero carries out Section 13 exercises going forward. We know from the disclosure provided in the Carbon Budget Delivery Plan Challenge that the immediate impact of the decision in the net zero strategy, Mr. Justice Holgate's decision, was that the department had to rethink the way that it carries out its assessment in order to ensure that the Secretary of State was given sufficient information about the quantification of individual policies and proposals, and also that he had the information necessary to make an informed decision on whether any shortfall could be made up by unquantified policies and proposals. So I'd expect that a similar process will be underway now to work out how to respond to that aspect of Mr. Justice Sheldon's decision, which said that it's necessary in order to take a lawful Section 13 decision to take into account delivery risk when estimating the likely emissions reductions that each policy and proposal will produce. And then at the level of principle, I think that the fact that there has been a second successful challenge to the government's net zero policy in as many years reinforces an important point about the nature of the government's obligations to achieve net zero by 2050. It's not just a government policy or an agreement under international law. It's a statutory obligation that Parliament has imposed on the government. And the courts are therefore rightly concerned to ensure that that statutory obligation and the framework within which it sits is correctly understood and adhered to by the government. And that's why they felt confident to find, not once but twice now, that the government has not discharged its obligations under the Climate Change Act.
Thank you very much for your time, Catherine.